would tougher sanctions not make it work better? I think, again, that misconstrues the nature of the legal system, a system that applies to governments and not to individuals. It's true that I think there are more effective sanctions in the WTO than there were in GATT, and I think that clearly has had an impact. Governments don't want it to happen. They don't want it to have to change. I think that has led to greater compliance. In many instances, we probably never can document how often the WTO has been complied with by governments around the world simply by measures that they have not adopted because they didn't want to violate the agreement. It's also led to the scorched earth policy in defending against claims that gives work to people like myself. So in that sense, I guess I'm all in favor of it. But I think the idea of sanctions as inducing compliance is overrated. As individuals, as I said, that may be true if you believe in the deterrence theory of punishment and so on. But governments, particularly the larger members, such as the United States, the EC, in particular, to pick the two 800-pound gorillas, they aren't complying with WTO panels to at least the limited extent that they are because of fear of sanctions necessarily. There's a bigger and a more important issue as far as I'm concerned, and that is that the system works for them. It's an instrumental sanction more than anything else. They certainly have some flexibility, the larger members, in avoiding a remedy. They can delay, they can obfuscate, they can go halfway and string it out a little bit longer, and they have a greater ability, obviously, to wind up paying compensation, as the EC's been doing for years on hormone-fed beef, if that's the way they choose to go. And developing countries do not obviously have this degree of flexibility. But the problem that the larger members, such as the EU and the US, face is that there's a practical limit to how far they can do this without destroying the system itself. No legal system needs complete compliance, and no legal system gets complete compliance. If you think that's true, go set your car on cruise control at the speed limit on an interstate highway and see what happens. You'll see non-compliance in action. But it does require substantial compliance, a very, very high degree of compliance. Otherwise, it'll just amount to nothing. And these 150 nations that have joined the WTO and have submitted themselves voluntarily to the jurisdiction of its tribunals are there because they think they get something out of it. They think the overall benefits outweigh the obvious political costs of time. And I think at the end of the day, that is the major sanction that has led to the success of the WTO and its dispute settlement system. And I think probably the best thing we do with the remedy is just leave it alone. It's working fine. That's it.
Thank you very much, David. We now have the final speaking of the panel. Jim, please.
Thank you, Tito. Thank you all. In 1994, I decided not to seek re-election to another term in the Congress, and I thought that would get me out of Washington for good. Turned out I was wrong about that, but I think I was right to decide to leave the Congress. In February of 1995, I was back home in Florida trying to begin practicing a little law, and my friend Mickey Cantor called me. He asked me if I would be willing to allow my country to submit my name as a nominee for something called the appellate body of the World Trade Organization. I agreed, and that's how I became one of the 7 founding members of the appellate body in 1995. 8 years later, I was the only remaining member of that original 7 who was on the appellate body, and I had judged a total of 60 appeals in the WTO. My last ruling was in something called the Steele case against a small country called the United States of America. After rendering that ruling as the presiding member on appeal, I came home and found that they would let me into the country, and I've been trying to find ways to keep myself occupied in the 2 years since. But it is 10 years to the very week today when I got that call from Mickey. So that causes me to reflect on what's been accomplished 10 years on. I don't profess infallibility for the appellate body any more than I would profess infallibility for the Supreme Court of the United States. They are human institutions with human failings. In my experience, whenever a country wins a case in WTO dispute settlement, they applaud the wisdom of the judges. And whenever they lose a case, they lament the fact that the judges are writing words into the treaty that are not there. You heard a little bit of that earlier this morning. A friend of mine who works for other friends of mine on Capitol Hill. You could hear it in every capital in the world. But I think the reality is what David said. The members of the WTO are largely satisfied with the dispute settlement system, which is why there doesn't seem to be much urgency for DSU review. On the other hand, I think there should be urgency in the process of DSU review. The WTO dispute settlement system is by far the most successful system for resolving international disputes in the history of the world. But in my view, it is a system much in need of further improvement. And in my view, it would be far better for the members of the WTO to make those improvements themselves by changing existing rules and writing new rules than to have the system struggle through to try to improvise results on a case-by-case basis. There are 3 points I would like to make about dispute settlement this morning. One relates to what needs to be done within the dispute settlement system itself. The second relates to what needs to be done outside dispute settlement, but in the WTO. And the third relates to what the WTO members should be doing in the wider world. Within dispute settlement, I think we should be trying finally to finish DSU review. There are some issues on which there is a consensus. I think sequencing is one. I agree with David about that. I may be more optimistic about remand authority than David is. I haven't polled the members of the WTO, but I think most of them acknowledge that it would be a good idea for the appellate body to have the right kind of remand authority. As someone who's had to struggle with these matters on appeal, the problem the appellate body often faces in trying to complete the analysis on legal issues is that there are no facts in the record to support any legal ruling. And the appellate body does not have fact-finding authority. The appellate body should not have fact-finding authority. That is the right province for the panel. But if you can't send the case back down to the panel to encourage them to find more facts on what you see as the relevant legal issues, then you can't resolve the dispute. And the purpose of the dispute settlement system is to resolve disputes in a positive solution. I think there are other areas in which there is a consensus. I think there's a consensus on enhancing third-party rights, for example. I would urge the members of the WTO to reach an agreement on those issues in DSU review in which they can reach a consensus and leave the others to another day. That said, I think there are some issues that ought to be featured in DSU review that don't seem yet to be on the horizon of the members of the WTO. I will mention a few of them in an effort to keep my commitment to Tito to be provocative. First of all, I believe that we need standard working procedures for panels, just as we have standard working procedures for the appellate body in dealing with appeals. We have a bare bones standard that sometimes is applied and sometimes is not, but we need some consistency in the ways in which panels mete out procedural justice at the panel level. We shouldn't have to make up procedural rules with every passing case. Second, I think we need rules of discovery. How is it that you secure the facts that you need to put into evidence? All members of the WTO are obliged to act in good faith in cooperating in dispute settlement, but sometimes that obligation seems to carry more weight than others. I believe countries have an obligation to be forthcoming in order to resolve a dispute in dispute settlement. We need rules that would provide the framework for such discovery. Also, what are facts? Panels find facts. The appellate body is bound by the facts found by the panel. What are facts? What is a fact? What is evidence? We don't know. There are no rules of evidence in the WTO dispute settlement system. This can mean that something will be accepted as appropriate evidence in one case, but not in another. We are, on a case-by-case basis, gradually beginning to deal with some of these challenges in terms of fact-finding, fact-gathering, evidence identifying. But the forum of a particular dispute, which has its own particular dynamic, is not the best place in which to decide what rules of evidence should be. The English common law system took 700 years to come up with evidence, and in most countries it's since been decided better to have it codified. And my suggestion would be to the members of the WTO that with respect to rules of discovery and rules of evidence, it would be better for them to appoint some among their own members or an outside expert group to offer the members of the DSB a view on what a framework for rules of discovery and rules of evidence and standard rules of working procedure for panels should be, and then the members of the WTO can do with it as they wish. The alternative is to continue to deal with these issues on a case-by-case, ad hoc, cumulative basis. And eventually that job will get done, but I don't think we need to wait a few hundred years to have what we need. We don't have that much time. There are other issues that are controversial that I think we need to put behind us, and importantly, especially, we need, if we can, to have the members of the WTO resolve these issues rather than have them dealt with on a case-by-case basis. I think the members of the WTO need to understand that any true international dispute settlement system needs to have a way in which affected outside interests can submit amicus briefs. The case law in the WTO now clearly states that amicus briefs are permissible. Panels and the appellate body have been quite restrained in accepting amicus briefs, but the law is clear that their view is that under the current rules they have that authority. Rather than making speeches about it in DSB meetings, I would suggest that the members of the WTO get serious about the issue and figure out the best constructive and positive way in which they, as members, can decide on rules that would govern the admissibility of amicus briefs when they should be admitted. There is also the issue of transparency. I've given whole speeches on this single issue. I won't now. But let me say that I applaud the recent efforts of the United States and the European Union to open up a panel meeting to public scrutiny. Surprise, surprise, they opened the meeting and the world didn't end. I think that the credibility of the WTO dispute settlement system would be enhanced significantly throughout the world if the WTO just opened up the doors to public and press scrutiny of what is happening inside the WTO. This is not an argument for standing for private parties. I'm opposed to that. It is an argument for letting the world see what's happening in an institution that has a great effect on the life and the livelihood of the world. I agree with David that we need to think much more clearly about remedies, about what in the jargon we call the back end of the treaty. We're now into the back end of the treaty in a lot of cases, and we need to think more seriously about more effective ways to achieve implementation and a positive solution to a dispute. Let me say something my former colleagues in the appellate body would never say themselves. They're being paid part-time to do a full-time job. They're doing their best to do a good job for all of the members of the WTO. The members of the WTO would be far better served if they would acknowledge that the busiest international legal system in the history of the world is in fact a system that requires full-time jurists and the full-time support that's needed to support such jurists and such jurisprudence. The members of the WTO need to begin thinking seriously about that 10 years on in WTO dispute settlement, because the appellate body is not going to raise that issue itself. Now, what about outside the dispute settlement system, but within the WTO? Well, there we have what I think is by far the most serious issue affecting dispute settlement, and it's something that doesn't relate to dispute settlement directly at all, and that is the imbalance in the system. David mentioned this, others have. I've written about this and talked about this a lot, so no one will be surprised to hear me say this. We have an extremely effective system for upholding rules. We have a very ineffective system for revising rules and writing new rules. This cannot be sustained indefinitely. We cannot continue to dump all of the most difficult issues into dispute settlement. There are any number of issues that are in the process of resolution in dispute settlement today that ideally should be resolved through trade negotiations. Those of us who worked so hard on the Uruguay round never intended for the WTO to become purely or solely a dispute settlement system. We wanted the WTO to be also an ongoing forum for resolving disputes through negotiation and for dealing with the challenges of globalization through rulemaking for an ever-widening and ever-changing world. The members of the WTO need to find some way to reach consensus on the pressing concerns they face in the Doha development round and beyond. That is by far the most important challenge facing the WTO. And outside the WTO, finally, my third point, there needs to be the political will to move forward in trade and to uphold the rule of law in world trade. It's really as simple as that. It's always easy in any capital back home to blame the WTO. But the truth of the matter is the WTO is nothing more nor less than all of the member countries and other customs territories of the WTO working together as something they have chosen to call the WTO. It's only the members themselves. You know, I was in Brazil, actually, and someone came up to me and said, why doesn't the WTO step in and fix this problem? That's not what the WTO is or what it's supposed to be. That's nothing I favor. If there is a problem, then the members of the WTO, Brazil, the United States, Europe, and 147 others, must together themselves figure out a way to fix that problem. And furthermore, they have to have a willingness to be bound by the rules that they themselves have written and on which they themselves have agreed. We can have a rule that says you have to stop at a red light. But if we don't stop at the red light, then the rule doesn't have much meaning ultimately. A final word, a personal word about the appellate body. I had the privilege of serving over the course of 8 years with a dozen different distinguished jurists. Each and every one of them was of the highest legal caliber. The one with whom I have not served is the woman who succeeded me from the United States, who's a dear and close friend of mine, and also of the highest caliber, Mary Jano. One of those with whom I served is Luis Olavo Batista of Brazil, a wonderful and brilliant man. I have watched as those dozen jurists have tried their very best in all their fallibility to do the right thing in every case and do the right job for the WTO members in every appeal. And I want those of you who follow the WTO to understand how distinguished many of them are and many of the sacrifices that they have made. 3 of those dozen are no longer with us. 2 of them died while working on WTO matters. Saeed El Nagar is no longer with us. Chris Beebe passed away in Geneva while he and I were working on a case. And most recently, John Lockhart of Australia passed away just a month ago. And I congratulate the members of the WTO on choosing such distinguished jurists who did so much to educate me and teach me about what the world of law and the rule of law should be. And I thank all of you for your time. I'll try to answer a few questions if I can.
Thank you, Jim. Before we jump to the questions, the speakers would like to make any comment? No? So, questions? Please identify yourselves before you. Ambassador Sergio here.